Well, I want to thank everybody for being here. Today, our special guest is Attorney Joe Engle, and I've heard him speak a little earlier this year, and he just has a whole wealth of information, a treasure chest of information dealing with estate planning, how to avoid probate, revocable trusts, living trusts, and he'll help you navigate that. And as I was saying to Kevin a little earlier, it's just like, even if you have a trust, this is a very important call because you should review it every so often. So without further ado, Joe, if you'd like to tell us a little bit about your background and we can get started.
Yeah,
thank you for being
here. Can you guys hear me okay? Can everybody hear me okay? Good. Okay, so my background, I do estate planning and I also do trust administration. Estate planning are the documents like the financial power of attorney, the advanced healthcare directive, the will, pour over will. All of those documents are designed generally to keep, well, the revocable trust specifically, but are to keep you out of the probate court, to settling your case, your estate out of the probate court, and for the efficiency of transfer of assets from one generation to the next. But not only that, when you become incapacitated, or if you become incapacitated, the trust and the power of attorney really covers those types of situations. So a lot of people don't realize how important the power of attorney is. It's in a very it's an interesting document. It can be drafted a lot of different ways, and their powers you're granting your agent. And we'll talk a little bit about that as well as the other, as well as some of the other documents. So my practice is estate planning. It's trust administration. Trust administration, when trustees have issues, trust is a very complex document. It's a legal document. Number one, people should really, it's a document to be followed. And a lot of times it can be 20, 30, 40, 50, 60, 70, 80. It depends on, it can be drafted very simply. Generally, when you have a very simple trust, you have some things maybe that you might have wanted if things become a little bit more complex, or it can be drafted with a lot of different things in it. I'm not going to go into the intricacies of all the different ways you could draft trust, but there are a lot of different, a lot of things to consider when drafting trust. If you're a blended family, for example, and you've got kids from two different marriages, or just one marriage in a blended family, that's a whole nother situation. And if you have a situation where you don't have children at all, and one spouse does have kids, that's a situation. If you bring separate property into a marriage, that really should be probably thought about very carefully when you draft these documents. So we'll go into a little bit of that, and then hopefully I'll give you some tips, a few things that maybe while you're doing. I heard one gentleman said he's in the process of doing and revising his documents now. So I can, hopefully we'll pass along some tips and practical things as well. So it's about protecting your money and property. Trusts do have asset protections. There's asset protections in trust, not in a revocable trust. Now that's important to understand. If you create your own trust and you get sued, and you are still alive, and that trust is revocable, which most people, that's what they create, those assets that are in your trust are subject to, creditors, lawsuits, just like anything else. So there's this trust. From that point of view, revocable trusts are that. But so if you're really, really, really serious about protecting your assets, and especially if you're in a situation where you're in maybe a type of job where maybe or a type of employment where there's a lot of risk involved, and your personal assets could be at risk, there are some things you can do. You would probably want to create maybe a different type of trust for that. Potentially could be an irrevocable trust. Irrevocable trusts are irrevocable, make it very difficult to get creditors to get to those irrevocable trusts. So let's go on to the revocable. I'm not going to talk right about the will right now, but I will talk about the will, because the revocable trust is the or a trust is the item that avoids the probate court. So if you just have a will and you or you don't have a will at all, and you have assets that are exceeding 184,000, that includes real estate. So if you own real estate in California, probably a pretty good bet. It's going to be more than 184,000, and it's just in a will, or it's not even in a will. It's just in your name, or even if it's in joint tenancy, it will be. Oops, lost you.
All right.
Okay. So it will be subject to the probate court. We're on the revocable trust. There we go. Okay, so, and I'm kind of like going to go over some of the items, but I'm going to spend time on just a few things that I think are really important to understand. So there are ways you can create within revocable trust. You can create irrevocable trust for your children or grandchildren or other beneficiaries. That's possible. We'll go into all that, but it is possible to make those revocable trusts are difficult for creditors to get out only when the trust becomes irrevocable. Unfortunately, when the trust becomes irrevocable, you won't be around any longer, but it can be very beneficial to your children and grandchildren and other people that you've named in your trust, and it's something to consider. All you really need to do there is create separate sub-trusts within the revocable trust, and then you can create some irrevocability and some asset protection for beneficiaries. So one thing that's really important in this slide is trustees. Very, very important that you have the right people manage as trustees. Now, when you create your own trust, you're the trustee. Generally, most people will do that. They're going to be the settlor or the creator of the trust and their own trustee, and then they're going to have some trustees. Now, oftentimes these are children, but they don't have to be. In fact, I had one client that didn't want his kids to be successors because he was worried about they would get into big fights and it wouldn't work out. So they actually named in their trust an independent trustee. And those are not necessarily done most of the time, but on larger estates, they're certainly done quite frequently. So the trustee is important. Then the question becomes on trustees, do you want to have more than, you want to have one, you want to have multiple trustees as successors. You might name one child, the one that you think the most highly of in terms of managing the whole family and all the assets, and then have someone behind them. Maybe, for example, second child. And then the question is, do you want to have co-trustees or not? That's really, really, you have to, it really depends on the family. If you have two kids that really get along and work together, maybe not such a bad idea. But if you have but it also is a recipe potentially for conflict. When you have two trustees or people that don't get along, and could be even division. So you have to think that out. And then if you want to maybe look to an independent trustee to handle things, that's a possibility too. And you could actually interview a private fiduciary, or if you have enough assets with a particular institutions, a lot of banks and larger banks, they do trust administration and things like that. That's also a possibility. But most of the time, for most people, they hire family members or they have family members. Now, one other thing about co-trustees and alternative trustees, it's really important that you let them know ahead of time and inform them of the duties of a trustee. At least try to inform them. If you look at a trust, it has various duties of a trustee. All trusts have something in there that says, what are the duties of a trustee? So it's not to be taken lightly, the trustee. It's someone you really want to be that can possibly even reach out for help. It allows almost all trusts allow trustees to hire other people, attorneys and accountants and all these various people to do that. But the trustees are a really important part of it, and you need to have backups. And by the way, you can draft a trust if you haven't drafted already, and maybe yours doesn't have this, but if you're in the middle of revising, maybe it's something you might want to think about. You can have trustees for distributions upon your demise, and you could also have them a trustee for your incapacity. You could have different people do trustees. So if you have, for example, let's say you have a person in the family or someone that you really trust is in the medical profession. Maybe you want them as your trustee for incapacity if something happens medically. You could also, by the way, this is a good time to, you could also name them that same person in your advanced healthcare directive or your medical directive. So this is something to think about. You don't have to have the same trustees for both distribution and health. They can be different types of people that do things. Now, simple trusts don't have that, but more complex trusts do. So that's enough about that. In terms of a trust, what's really, really probably the most important thing that I'm going to talk about is the next step: transfer of ownership. What does that mean? You create this wonderful, this beautiful document, well drafted, spend a lot of money with attorneys potentially to do it, or people even go online to do it sometimes. But you spend all this money, and then you have this document. What does the document itself do? And by the way, I'll stop after this slide if anybody has questions and answer some questions along the way. What does the document do if you have, let's say you name in the trust, on a schedule on the trust, you say you have your house and you have your assets, your checking and your savings and your maybe your retirement accounts and maybe non-qualified accounts, such as just stock accounts or mutual funds. You name all that stuff in the trust. What does that do? What does that do for you? It does almost nothing for you. In order to have a trust, an asset, be part of your trust, it has to own the asset. So the easiest example is a house, and it translates to all of your other assets except for 401ks, IRAs, and qualified accounts. For example, if you have a trust and you titled your property, you would need to transfer title to you as trustee of your trust. That requires a deed. You have to record the deed with the county. That makes the trust the owner of the asset. If you have a mutual fund account with whatever money you have in it, and you want, believe me, when you create your trust, the idea of creating it is so you want it followed, the distributions especially. You want it followed. You want the beneficiary, the people that you have named in your trust, to get the distributions in the way you want the distributions. And you might have different trusts for different people within your trust. It's a little complex, but you could do that even, all children are not created equal. Some children might be perfectly okay with a complete distribution of your trust assets at the age of 25 or 30 or 21 or whatever. And then other children may never be suitable to get those assets. And that's what I mean by asset protection. You could actually set up a lifetime trust for one individual and a complete distribution at a particular age for another person. So the point is, you want to make sure that when you create this wonderful trust that you created, that you have the property that you want to have your asset, whether it's a mutual fund, be owned by the trust. And the way you do that is in this particular case, you would contact your financial planner and you would give them a copy of a certification of trust, which you will get if you should always have a certification of trust. It's a 2-page document versus a 40 or 50-page document. And you give that to the financial planner, and then they would title the property as your name, trustee of your trust. That's simple. Sounds simple, but a lot of people lose this. They don't do it. They just get their trust. They don't look at it for what one gentleman said, 10 years. They open up new accounts. They never get it done funded properly from the very beginning. funding of the trust is the number one most important thing you can do to your trust. And number one most important thing, I think, you can do with your trust. So that's really important. Now, one other thing about the trust, and this slide says it can't be used for asset protection. It's actually incorrect. A revocable trust can be, but if it's irrevocable, it can be. And if you set up sub-trust, you can get asset protection. But one thing that's really important, that's a recent law that went into effect, was the Secure Act of 2019. That act governs retirement plans. Now, are retirement plans important to your distributions to your beneficiaries? They are. So you have to give a lot of thought. Not a lot of thought in a lot of cases, once you draft the trust, has to go into whether or not you're making the trust the ownership. You are going to do that on almost every account. Life insurance. You're going to make the trust own life insurance. Or you're going to make the beneficiary of the trust. You can make the trust the beneficiary of that life insurance. Why? So it gets distributed the way you want it to get distributed through your trust. But the Secure Act of 2019 was really reduced and changed the way retirement distributions are given out to beneficiaries. Doesn't affect the spouse, but it does affect beneficiaries. So if they inherit IRAs and 401ks, it used to be that you could stretch those out over the lifetime of the oldest beneficiary. In other words, from a tax point of view. It's very important from a tax point of view. You could stretch them out over their lifetime. Well, if you have $1 million sitting in a retirement account in a 401k or a IRA, is there now, under the new act of 2019, the law, unless you're what they call an eligible designated beneficiary, meaning that you're the spouse, or you're a disabled individual, or you're a minor, you can't stretch them out beyond 10 years. You can't stretch them out beyond 10 years. So you really need to, when you're doing these types of things, you really need to think that's probably the most, for me, the most interesting part of it is that you have to put a lot of thought into how you're going to handle your retirement accounts and things that you can do to offset taxes, higher taxes, and things that you can do to make sure that the money is being distributed to the right beneficiaries. If, for example, if you have a special needs child, or whether or not you want the trust to be an outright in that particular case, you would set it up to have that special needs sub-trust of the main trust to be the beneficiary, or to be named as an owner, as the beneficiary. And so you want to give that a lot of thought. So I think we can go to the next slide, and this is a good time to stop and ask if anybody has any questions. Take yourself off mute, or I'll just keep going on. Okay, so I kind of started talking about this for life insurance policies and retirement accounts, etc. This is what you want to think about. A lot of people just name their spouse, maybe, but even if you do that, which is okay, you don't necessarily have to name, that's fine. And you want to name your spouse as a beneficiary in a life insurance policy, you should name the trust someone as contingent. It's kind of a glum. It's not the most, positive type of conversation to have with everybody, but if something happens to both of you at the same time, what's going to happen with that asset? Who's it going to? Do you have those properly named? And I'll get to that question in just a second. But you want to make sure that you do that. There was a question, and okay. So the question is, what are fraudulent transfers? Fraudulent transfers are, one example of a fraudulent transfer, someone creates a irrevocable trust. They're in the middle of a lawsuit, and they create an irrevocable trust and transfer assets into that trust to avoid a lawsuit. It's perfectly okay to do that if you if you aren't involved in a lawsuit. But if you think that will work in the court of law, you're mistaken. Courts see right through that, and that's a fraudulent transfer. It was not done with the intent. It was done with the intent to avoid an obligation that is already in existing. That's the easiest kind of fraudulent transfer that you can make. Fraudulent transfers you got to be careful of, especially in the bankruptcy court. But that's about all I'm going to do about talking about fraudulent transfer. It's kind of a subject it's more of a subject for a lot of bankruptcy lawyers, because that seems to come up, that people are doing a lot of transfers of assets during bankruptcy, which they look at very carefully. All right, so we can go to the next slide, I think, on this. Okay, last will and testament, also called a will. Okay, so generally when estate planning attorneys we will always draft a will in the estate plan. And it's really a pour over will. It's called a pour over will. What is a pour over will? A pour over will is, okay, you haven't reviewed your trust in 10 years, but you've got this trust and you have an asset that's outside of your trust. You didn't put it in your trust. And it's substantial. In other words, it's at least over $184,000 assets, a couple $100,000, for example. The pour over will says it doesn't avoid probate. It doesn't avoid probate, but what it says, look, I want this asset poured over in my will and distributed along the lines of my will, of my trust. So it's drafted. You draft the trust first. The trust is in existence, and then most people do this right at the same time. But when you're drafting the will, you name the trust in your will, and you want everything to pour over to that. All attorneys that are estate planning attorneys, I would say 99. If they don't, it would be very unusual that they wouldn't draft this document. It's and it also has its use in other places. For younger families, they're naming guardians, for minor children. But the key thing to remember, a will is a very, very, very simple document. It doesn't go into all of the things that a trust does with distributions, and it doesn't avoid probate. It requires probate. And unless the assets are less, if you have if you have a stock, for example, that's worth $150,000, you can do there is a procedure for assets that are lower called an affidavit procedure, which doesn't require probate. Any questions on that slide? Okay, let's go on.
We do have one question. Is that like a catch-all?
It is in the event it is, but yeah, I mean, if the trust is in existence and you write in your will that that's what you want to have happen, and you can also write in your will that you want to have, even if that trust, let's say that trust, if you don't fund a trust at all, it's not a trust. Okay, so you can also create in that pour over will a document that says that it will allow your personal representative or your executor to create a trust, to actually establish trust, like the one that wasn't ever funded or nothing ever happened with the other one. So it could do that. So from that point of view, it's helpful. It's better than not having anything at all, for sure. And so that's pretty much it. That's pretty basic. Other than that, so
and then
go
we
ahead.
had another question. What did you say is the most important thing to do regarding assigning ownership of the trust when it is first created?
Funding the trust. Putting the assets you have. If you have banks, go to your banks, have your assets either. And now banks, by the way, here's another thing. Don't be surprised if you create your trust, if they say, no, we're not going to transfer that. We're going to have to either open up a new account. Some banks will allow you to transfer to a trust. Other banks will say, we're not going to do that unless you open up a trust account, which is a little inconvenient, but not the end of the world. You just won't have that other account anymore, but don't be surprised. So you can't always just transfer that. So funding of the trust, it's not a matter of assignment. That's a legal word, assignment. Assignment doesn't do it. Assignment, if you have an assignment that assigns everything to your trust, that does not avoid probate. What it does, though, is it shows intent to put it into your trust. So I actually do an assignment on all my documents that says I want my clients everything assigned to their trust. I put that in as kind of a that is kind of a fallback situation. It avoids a full probate. You can usually petition the probate court and get that done a lot simpler and with a lot less time and money. So you should, if you're thinking about it, good question, good thing to bring up. If you don't remember anything else, or you remember a few things, you want to create docs, you should definitely have an assignment of assets to your trust. But it doesn't avoid probate. Okay.
Thank you.
What do we have next? Keep going. Okay, so this is a really this also is a document that comes up a lot. Oh my gosh. I get it a lot because I guess this is what I do for a living. So you may not think that a power of attorney is important, but what does the power of attorney do? The power of attorney, first of all, you can, like a trust, you can draft the power of attorney with a lot of powers. So I go over my powers of attorney with clients very carefully to make sure that these are the powers you want your agent to have when you're not able to act for yourself. That's number one. They're not all created equal. There are generic things you get online and things like that, but believe me, they're all different. And the interesting thing about a power of attorney, it comes up a lot with and what is the power of attorney? Let's first of all, what does the power of attorney take care of? Does it take care of the trust? No. It's the trust stands on itself. It's governed by the trust. So if trust assets are involved, you're not going to use a financial power of attorney unless you name in your trust the authority that allows for a financial power of attorney. Now, when you do that, though, you run the risk. You have to be careful of that when you do that. I don't do it most of the time. There are times where I do think it's a good idea for clients, but because when you if you give them power, too much power, they can change the dispositive sections of your trust. They can just change, if you give them so much power, they could potentially change your entire trust in terms of distributions. Now, if you have an only child and that's it, and they're the only one that's taking under this trust, but the power of attorney allows them to do a lot of different things, you can give them quite a bit of power, because they're the only child, they're the only one getting everything, that's fine. But if you have multiple, say you have 3 or 4 children and maybe they don't all get along so great, you may want to rethink about who you're giving that power to. But I would say generally don't recommend. There's certain powers you give them and certain powers you want them to have, and certain powers you don't want them to have. But it is super important because it covers everything that's not a trust asset or that's not part of your trust. Well, what's not part of the trust? The IRS, the Department of Water and Power, your bank accounts that don't end up being in the trust, your mutual funds that don't end up being in the trust, money, I'm talking about money, all of those things. And by the way, in the trust, there's a trust. It covers incapacity when you're not able to manage yourself. This really happens a lot of fun. Unfortunately, I see this a lot. These powers of attorney come in very handy in the realm of mental illness, when people really have maybe potentially a history of problems, but they've had the ability to maybe create some documents. That's one thing, and they name people as power of attorney. This keeps people out, this document can keep people out of the conservatorship court or the probate court, which deals with conservatorships. It's a really, really important document. Again, if you're an estate planning attorney, you're going to draft this document and you're going to go over it with your client. It is exceptionally important, and there's so many different things it can do without going to every little thing. You could do an entire class on the financial power of attorney, but we're not doing that here tonight. Is there any questions on this? Okay, what's next? Okay, the medical power of attorney. This is kind of an interesting, a lot of it deals with end of life, but not always. It can be incapacity. These people, like I said earlier, a lot of times the medical power of attorney doesn't have to be, this could be completely different than the financial power of attorney. Some people are really good with finances, other people are really good with medical. They're not all created equal. You might have somebody that's very compassionate, that's very, very knowledgeable, that could be a really good really good for your advanced healthcare directive or your medical power of attorney, that you'd want to have information go to in the event that you are not able to understand it. This is really important, right? If you have a medical situation, doesn't mean it's the end of the world yet. It means that you have someone that you're not able to just deal with at the moment. You want this person to be, or people, to have access to, your records. Now, the way you get records these days, there's a document that goes with the medical power of attorney. It's kind of a separate document. It's called the HIPAA form, Health Insurance Privacy Act, Health Insurance Patient Privacy Act. The reason why the HIPAA is really important, and I'll take that question again after this one. The reason why the HIPAA is very important is that it gives your authority to the doctors to release your medical information to your agents when you cannot do it. And generally you're going to name the people that you name in your medical power of attorney or financial power of attorney in the HIPAA form to get those things. That's really important. You want to make doctors, medical, these are all huge companies now, right? Kaiser and Blue and USC and UCLA and all of these healthcare is just all about corporations, right? Well, guess what they don't give out unless you have this document and these documents. They're not giving out your medical information to anybody unless it's a court order. And then it takes a long time to get it. I have a matter that's before the court right now where it took me 6 months to get information from Kaiser on a case that I have. They don't give it out. They don't want to give it out. But under this, if you're gonna get it, they've got to have the authority. The HIPAA form is very important, and the Advanced Health Directive is who you want to have those people, again, like the financial power of the attorney, and I didn't mention this with that, and your trust, you want multiple people involved in this. And you want people that you feel are going to be good and around when it becomes time that you need them to do that. The other thing of the medical power of attorney, you can also refer this to as an advanced healthcare directive. This gives the guidance of how you want to end your life. And it gives it so it's really important. You don't want, you want your next of kin to have instructions. You don't want to have it all be on them to decide. That's not a responsible thing to do. You want to make sure that you tell them what you want to have happen when it's time. And if you want to do any kind of donating, that's part of it. If you don't, that's okay. It's just part of the advanced health. That's part of it. So it's not only a medical, it's the advanced healthcare directive and the medical power of attorney are really one document, but they do, it's called an advanced healthcare directive, but it also gives the medical power of attorney, and the HIPAA form is for when it's not necessarily, maybe you want to get a second opinion on something and you want to get those records to do that. You know, that's why all this stuff is important. Okay, so there was a question. What was the question? I can't remember who it was.
The
Someone
question
wrote-
was, are your mutual funds not able to be included in a trust? What happens to those accounts?
Everything is able to be included in the trust. Your mutual funds surely are with qualified account with mutual funds that are not qualified. When I say qualified, 401ks, retire, 40 IRAs, 401k IRAs, what are the Roth IRAs, things, defined benefit, those cannot, the trust cannot own those assets. The trust can be beneficiaries though. That's what you want to give thought to. Remember, I was talking about the Secure Act of 2019, how that changed things. You may want to set up trusts and have the beneficiary be those trusts be beneficiaries of your IRA or your 401k, but they can't own the account. You see the difference? You can't give the trust certification to your financial planner that does your 401k and say, I want my trust to own that account. No, you can't do that, but you can have the trust be the beneficiary. With mutual funds and everything else, mutual funds, life insurance, the trust can actually own those, but mutual funds, to your question, absolutely, with a trust certificate, you would give that document to your financial planner, and you would definitely want that done, and you would want that, you know, executed that way, because the trust is a controlling document. When someone hires me, I spend 80% of my time on the trust. The other documents I can draft pretty quickly, but my time and thought, really, my mental, all really comes into the trust, because it's all about distributions, who you're giving your money to, when you want to have it. Do you want to take care of nieces, nephews? Do you want to take care of, you know, for younger people, maybe their parents, maybe sisters, brothers, you know, that's the document. So when you have your assets, you want the assets to flow through your trust so you can, you know, so you can get the money to where you want it to go. It's really that simple. And so it can be with the retirement accounts the exact same way, where you make the trust the retirement, you make the trust the beneficiary. But, you know, it's that one does require discussion and thought. And all situations are different. But all the other ones are not as, they're not as much thought. The reason why they require thought, if you have a lot of money in your trust and you're going to hold the money in your trust and the trust is going to have income, trust tax rates are much higher than personal tax rates. They kick in much sooner. So that's what people, they really have to think. Because if you have like let's say if your trust is earning more than 14,000, once it's irrevocable and you have all of this money earning income and it's not being taken out of the trust, then you're going to have then the trust tax return is going to be substantial. But there are ways to not have that as well. And there are some reasons to keep, regardless of the tax rates, you may still want them to be in your trust. It's really a multi-thought level consideration. You think about a lot of different things when you think about qualified accounts in your trust. So that's kind of that. So yes, long answer, didn't need to be that long. Certainly mutual funds, all assets can be owners of your trust for the most part, except for qualified accounts. Is there anything, I think keep going. Let's see. We spoke about that. I think we've covered almost all of them. I think that pretty much does it. I have one more. That's the HIP author. I already said that. Keep going. Let's see. All right. Now, okay. So I think I've covered everything I want to cover now in this. The only thing that I have, Candace, I have a newsletter that's educational that goes out monthly. And it's all about, well, it's a lot more than what I just talked about over time. And it's designed to educate. And I have one for advisors, Candace, just so you know, and I have one that's for prospects, clients, or people that are not in the advisory role that I send out. So if anybody would like to be in that, I thought I set up that slide. I can give you my email. I guess I didn't. I thought I named my email, but apparently I didn't.
It's
Maybe I did at the beginning. Let's go back to the beginning.
okay.
No, I didn't do that. About the next slide. Man, am I a poor marketer, Candace. I am a poor marketer. But my email, I'll just give it to you. It's Joe at Engle, E-N-G-L-E, legal.net. If you email me, I will put you on that and you will have that. And if you get tired of it, never want to opt out, that's fine. But it is really, really good stuff. It's very well thought out newsletter. Any other questions? If not, I'm going to give it back to you, Candace.
Well, I kind of do have a question. You mentioned qualified accounts, and you talked about how the trust is a beneficiary of the mutual fund, but life insurance owns the mutual fund. Could you kind of clarify between that again?
The trust cannot be owner of qualified accounts.
And
so if you try to put your 401k in the name of your trust, it can only be a beneficiary. So the idea of the beneficiary is that if the trust, it will follow the terms of your trust because you created this document, all the distribution. So there's a lot of, you may want to, have your trust control. The trust is a controlling document, right? So if you make the trust a beneficiary, then the trust will control how things get distributed. Mutual, everything else, like a life insurance policy, the trust can own a life insurance policy. The trust can also be a beneficiary of the life insurance policy if you want that. The trust can also be a contingent beneficiary. So if you name your spouse first, but you want to name contingencies, potentially you would want to name contingencies if like who would get it after your spouse. And then you would name the trust as a contingent beneficiary. You could actually do that.
Okay, so what exactly is a qualified account? Is that like a checking
Qualified
account?
account is like, tax deferred, like, how the government, you get the 401k and you can
retirement accounts.
Retirement accounts. Yeah, you can retirement accounts.
Okay,
Yes.
Cool. Thank you.
Sorry about that.
No, that's cool. I totally get it.
I guess I should have just said retirement accounts.
Boom, there you go. No, it's good. This is why we have these conversations, just to specify, because there is a lot of information. And although a lot of it does seem, we've all heard it before, it's always good to reinforce what this is. How about if the property's in an LLC? How does that affect ownership or the beneficiary status?
Okay, that you can assign the LLC to your trust, and the trust would have an interest. The LLC would be the controlling document, and the trust would be the assignee. So you would then, your trustees, if something happens, or you could do something with your trust to have everything continue to go on and and have that interest.
So how about for privacy? Say it's a celebrity and the property's in an LLC. Is it smart? I mean, which goes first? You put the property in the LLC before you start your trust, or what if you have a trust and you want to put the property in the trust?
It just depends whether or not you started or before, afterwards. It really depends on individuals. Like, if someone's has assets and they're forming and they already have a trust, then they would be forming an LLC, right? So LLCs, or if someone depends on their priority. Like I had a client, they wanted to do a trust and an LLC, but it was really important to do the LLC first. So it really depends. As in, they say in law school, it depends. It depends. process.
We say that in real estate too. Thank you so much. Kevin had a question.
I do. Thanks for the presentation, Joe. It answered a lot of things that I was going to ask you anyway, but two things stick out. One is, did I hear you correctly when you said certain assignments that have to do with financial or institutions, they're taxed at a higher rate in the trust than they would be individually? So if you assigned everything to the trust,
Not while you're alive, because it's a revocable trust. So under the trust rules, everything flows over and you pay rates just on your personal rates. But
okay,
when the trust becomes irrevocable, like you're not there and then your children have it,
right?
and if you set up a lifetime, it depends on what kind of, but if you don't, like for certain accounts, if you want, you would maybe want to give them flexibility to have withdrawals, depending on the family situation. So those you have to think about whether or not you want your trust to hold on to the assets once they become irrevocable. While you're alive, it has no impact on anything.
I'm talking about after I'm gone and setting up.
After you're gone, if you have set up, for example, lifetime trusts, there are ways you can do things like where they're passing through the trust on their way to somebody. You can set up what they call conduits. That way they're taxed at the individual's rate versus the trust tax rate.
I don't think I'll probably be that sophisticated. What I want to avoid is this happened to me as the executor of a friend's estate, and one of the assets of the account happened to be an investment company, Ameritrade, or one of those, and he had 5 accounts there. One of them was a 401k, and unfortunately, whatever, he was very thorough in everything else, and all the beneficiaries and all the distributions of 4 out of the 5 of those accounts went through beautifully. His own personal retirement account got stuck in probate because it wasn't, the instructions apparently didn't qualify to have it move to something that either the executor or the beneficiary could control, and it had to go to
Right. So that's, yeah. So the thing, if there is one thing to think about, that happens, that's just a mistake, and mistakes happen. Probably didn't name a beneficiary properly, or there was no one there to take it. That sounds like that's what happened if it ended up in
That's
probate.
exactly what happened. Yeah.
So what you in the trust, since you're doing this revision process, there's a schedule. It's called Schedule A. It's the last page of the trust. You don't even need after the attorney drafts it, or whoever you're going to have draft it. You could name that if he would have named that account in his trust, it would have avoided a full probate. He could have petitioned the court. There's now called a petition, where if you show the intent that you wanted it in your trust and you didn't want it, you wanted it in the trust, then they could petition the court. Much less expensive, much less time. You can usually get those done in about 3 or 4 months.
Final question. I'm updating a trust right now that was created and amended once in about 2008. So I'm going to have to restate it because so much has changed, and then I'm going to have to populate it with current information. My question is simply this: if it's created by one legal firm or attorney, can it be updated by a different attorney and still hold the same kind of?
Absolutely.
Okay.
Yeah.
Thank you.
Yeah. That was an easy one. Thank you for that. Do you have any other questions?
I have a
It's
question.
always a pleasure. I love speaking about this stuff. You wouldn't, I do really enjoy it. It's really, really surprisingly, but I do like it. I guess there's something wrong. There must be something wrong with me, Candace. I'm not sure what it is, but
No, you know what? It's so important to love what you do. And while very
Yeah,
appreciative, I think Rebecca had one final question or
okay.
thought.
Okay, Rebecca.
Yeah, I did. And then I started laughing at something you said and I've forgotten already. So,
Well, if it comes to you before we close, let me know.
And his contact information's in the chat. You might need to scroll up a little bit, but his office number as well as the email address is there. Kevin, did you have it? Oh, do you have it?
yeah, I do have it. So I had a transaction, a real estate transaction, where I had closed a trust and created a new trust.
Right.
And I had a real estate transaction after creating the new trust. And I had transferred my property into the new trust. But the escrow people didn't accept the new trust. So I had to sign an affidavit confirming that I had indeed superseded my old trust. And so I guess my question is, why did they question it? How do you close an old trust, which is revocable, hence the word revoke, to validate a newly created trust? The lawyer was deceased. My attorney was deceased, the original trust.
And then you just went out and created another trust, right?
Online during the pandemic through LegalZoom in New York, something like that.
Yeah, so when you create your new trust, the first thing that I state is that you're creating a new trust. First of all, you created a trust in so-and-so whenever you did that first trust. And now you're completely restating and amending a new trust. And this supersedes and revokes the prior trust. And that's in the document.
Yeah, that might not be in the document. I couldn't find it at the time that the escrow company wanted it. That's why I did
the good thing is that they did it with an affidavit and they were able to do it.
It was touch and
That
go.
would not always be the case, but it depends on, in your circumstances where you were the only person that created the trust?
Yeah, I was single at the time, yes.
Yeah, so you were single and you were creating a new trust and you were doing it again yourself?
No,
Or was
now
this
I
a joint trust?
No, now I was doing it married. The second one.
Okay, so you did a joint trust.
Yep. Yeah,
So you could have, there's a few things you might have done, but it sounds like it all worked out, so.
I was lucky that they accepted the affidavit and
Yeah, they accepted the affidavit because it's not the escrow people, it's the title people, because title, just so you know, they insure the chain of title.
that's
And they're
right.
not going to do
Title.
anything, they're not going to do anything where they can't insure it. So they said, okay, yeah, we're good. All's good. Just sign this affidavit and we're fine. So they took care of it.
That same title company wouldn't accept my mother's power of attorney. She's incapacitated. That was drafted in 1972 that listed my brother. And so they wouldn't accept him as power of attorney. So he had to go to the estate attorney and get a new power of attorney written up. So how long do power of attorneys hold water? I mean,
Yeah, I mean,
was,
it depends on the time. It depends on the power of attorney and and how long they've been around. That's a pretty old power of attorney, 1972.
yeah, well, she's going to be 97 in April.
So
Still hanging in there, but incapacitated.
then the question is, how do you create a power of attorney if you're incapacitated?
That was the problem. And of course, it's on a weekend and the property's closing and title is and escrow are putting the brakes on. And then the estate attorney was.
Did she have a trust?
Oh, yeah. And so, and the estate attorney, yeah, that's all in place.
That's probably going to be way too long for what we have here. That's
Right.
that's interesting, but
But that's
anyway.
exactly what went down. Yeah.
Yeah. Yeah, that there are some things that happen. That's I wish it was all smooth. You just created these documents. They're just wonderful. Everything's great. You're not gonna have any trouble. All's good. Unfortunately, our world doesn't work that way. Everything has to be more complicated than a lot of things become more complicated than maybe they should be. Sometimes it's good to be complicated, but other times, you know.
May I just ask one more quick one?
Sure.
The restating of a trust that's already in existence and repopulating it, do all of those items that are in the preceding trust need to be re-registered, or do they carry over
No.
to the restated trust?
First of all, yeah, they're not going to be the same. It's 10 years or so later. There's going to be different kinds of things in the trust. But when you restate and amend, you're really doing the most important things, right? The really things that matter.
The house?
And those are just the things that you want done with your property and how and your agents, your trustees and distributions and all of that. So it's going to be a different document than what you did 10 years ago, but the dispositive provisions are going to be the way you want them to be.
Okay, if they aren't changed in the old one, they don't have to be repopulated and restated in the
And
new
they're
one.
going to be done that anyway. Nobody's creating these documents. You don't have attorneys like writing out these documents and spending, they belong to subscriptions and they make decisions and things are just automatically populated that, there's what they call boilerplate and those go in. So
Okay,
those provisions are going to be in there and then you'll review it carefully. And then hopefully, everything will be just the way you want it. There'll be no problems. You don't have to worry about that.
out with the old, in with the new, and the same.
Exactly. Don't worry about that because the laws have changed, things have changed, trusts have changed.
Good.
Document
Thank you.
paper, it's different.
Well, thank you, Joe. The information you imparted today was so valuable. I'm sure everybody on the call learned something, and we all know how important it is to protect our assets with estate planning. So I cannot thank you enough for your time today.
Well, I appreciate you having me. Thank you.
Thank you.
And I appreciate that other referral you're going to make for me. That's cool.
Yeah, with AGLA. They're a good group.
That'd be awesome. Looking forward to that.
Cool.
Thank you.
Do you want me to leave now? Should I leave?
You could stay on the call if you want. Natalie is our mortgage rep. She works with Movement Mortgage and she usually reports back to us what's going on. And now with rates going up yet again, I'm sure she has some information. If you want to hear about it, we'd love to have you stay on.
It's almost my bedtime.
Oh, no way. Or at least dinner time,
I
right?
would stay on. So I think I'm gonna sign off.
Okay.
But I appreciate it and you guys have a good evening.
Thank you, Joe. Be well.
You're welcome.
Thank you,
Take
Joe.
care. Good night.
So Natalie, all right. Yesterday was another 0.75 rate hike. What are we thinking? Where are we?
So yes, the rates came up yesterday again, which we were expecting. They're saying that they'll probably come up again in December by half a point. Rates today were up a little in the morning and then we had a midday down. So we're the same as we were before the rate hike. Remember, it's the Fed that raises their margin rate, not like mortgage rates are directly affected immediately.
The Fed rate right now, what number are they at?
7.
Wow. Okay.
7. Yeah. So if you want a HELOC, or if you want, a lot of my HELOCs, if you have equity in the property, are only at like a point above or 0.99. Some are at 0.49. So now your equity line at best is like 7.49. Most are 8.5. Again, not terrible for equity lines. I'm feeling it the most in like a car loan. Like if you need a car loan, that's at like 9. Your credit cards, I'm sure, don't look great. either. I only use Amexes, so I don't really know and I pay every month. But I'm sure credit cards don't look great right now either. So I think it's going to cause a lot of slowing, which is what, the Fed wants. Yeah. Oh, I thought you were going to say something. But I think the slowing is going to push us and pause us into this whatever mini recession that they're talking about. And now they're pushing that rates will come back down in like April of next year. There's like a financial expert that I spoke to at the beginning of the week that said that. So I'm not really sure. It feels hasty. It feels like we could have done this a little bit slower. I'm not sure why they are so afraid of the inflation numbers. Yes, they're there, but also everybody's making more money. So it feels like if you do the numbers and you look at the graphs, the payment coming up $500 a month, $600 a month from where it was. If you look at what the borrower is making more, if they're making 10% more or 7% more, not that all of that should go towards their mortgage payment, but it gives room for the fact that, rates are higher now. I think honestly, rates obviously went way too low. I don't think any of us needed or wanted them to be in the twos. We were all fine. It was unnecessary. And it's caused us to push into, 7% so quickly in this way that feels also very unnecessary, at least based on where we were. Why didn't we stay in the mid threes to high threes? And then at this point, push into the fives, right? Like everything could have been a little bit more moderate. It was extreme. I also feel like, and I've talked to clients about it, like none of us needed 30% more equity every year. Like none of us asked for it, wanted it, needed it. Like my property going up in the value in the way that it did in the past 3 years, it's outrageous. I didn't expect it. I'm perfectly fine with it, what we're calling decelerating. Like, I don't think values are going down necessarily. I think they're decelerating. I mean, yes, in Silver Lake and in some places, I've seen my property go down about 7%. But even still, if you look at the difference, if you look at where it was in 21, it was unnecessary. It shouldn't have ever popped up that much. There's no way to manage the market when that's happening, I just think the bust is so big. It didn't need to be this big. We were expecting a bust to happen, but I think it's super scared a lot of our buyers away. I think they're like spooked. And I think it's scaring our sellers who have rates at 2.99 and don't necessarily feel like they want to sell, because what are they going to get? A rate that's 6.5 or 7? You know what I mean? So it's just like, if they got a rate in the high threes and the rate now is in the mid fives, that's different than high 2s to 7. You know what I mean? So it's just it's an interesting time, though. I do think it's going to shift out of this. I think we're in like a moment of inflation, where everybody's kind of holding. And they say that when there is inflation, people save. People don't spend as much, people save. The rate is higher at the bank. You can put money into a bond and make a little. So people kind of save their money during times that have very high inflation. And our inflation rate's pretty darn high right now. It's like 8. They want to get it to 2. Just like crazy.
I think they're just lying to us. I don't mean to be mean, but I think you gave a really great analysis. Rates didn't need to be that low. Prices didn't need to be that high. But I think maybe when the cost of money was almost, I don't want to say almost zero, but when it's like between 2 and 3%, even to get a loan, of course, people feel flush, and it's like, that's probably what spurred the housing market and prices at that point in time.
Right.
I
But it's
appreciate what you're saying.
spoiled. It spoils everyone. Like
Yes.
my 0% car rate that I had, now that I have to pay 9%, it's like, what? You know, I'm gonna just buy a car. I'm
Do you
not.
lease, by the way?
I did, but my lease is up, not to get like all personal, but my lease is up. I extended for 6 months because I have this incredible rate.
Me
And
too.
now it's gonna double.
I'm in the same position.
Literally double if I want to continue to lease.
Mhm.
And if I buy, the rate's 9%. I'm just gonna have to pay for it. You know, I'm not paying 9%. You know, like, but I think if it were 7 and maybe I had a rate of 3, then I wouldn't be as spoiled and I would understand the difference and be okay with it. I'd be like, all right, it's 7. I was at 3. It's much more, but it's still okay. I was at 0 and now I'm at 9. That doesn't feel okay. And it feels like they could have managed that better. Right? Like, I don't know. But
You should serve on the board of the Fed.
oh yeah.
Yeah, that would be fun, wouldn't it? I think we should all like, oh, never mind what I was gonna say, but
Its role is purely to curtail inflation, really, you know, so they know
Certainly.
where the market is going. They are concerned with inflation.
Of course, and it might curtail faster. They might, there's some people are saying that they might not raise it as much in December. That this raise is going to push us to a place that they feel at least a little more comfortable and like hedge off at the end of the year and not. And then in 2023, not raise it again until maybe end of 2023 if things don't cool down. But it felt like the temperature in the room was better at the Fed meeting this past couple days.
Okay, it's good to know. That's good to hear.
Yeah.
And Diane, she just wrote, I'm hearing about sellers buying the rate down to make a deal, which is exactly what we've seen as well. I have not dealt with it personally, but with other agents in my office, we've seen that. What has been your experience on that front?
Yeah, so there's a couple cool things that, I mean, rates are being priced to pay a point. So since buyers have a little more leverage, they can ask for the point from the seller, either upfront or while in escrow. The reason almost every investor is pricing to make a point is because they know these loans are probably temporary. We don't know for sure, but most likely these loans are temporary. And nobody's giving $1 million for free, right? So they need to make their money somehow. So they are pricing the rate to pull a point in upfront to make that money upfront, right? So that's the points. And you can get a seller, it's 0.1% of the loan is 1 point. Most investors are pricing at a point. Today I had very good pricing. Duplex FHA, 6%. Duplex FHA. At 6%. Excellent. 1.24 million. I'm getting 6%. So excellent rate, but they wanted 1.25 upfront, not just a point. It was like the threshold pushed up, like 6.3 was at a point, but 6% was only at a point and a quarter. You're doing 6% for a point and a quarter. It makes financial sense to do so. You know, that 3/8 that it buys you is worth it. That's a large savings in monthly a month. So it's those kind of things. You just have to read the rate sheet really, really well to understand what those options are, because on all rate sheets now, they play around with the rate. Like, oh, do you want to see a 5 in front of it? It's not going to be as bad as you think because we're making 6 and 6.1 not look as good. So then you're like, oh shit, the 5.99 is only a quarter more. You know what I mean? So they're trying to entice you to pay a little more so they make more money on these loans that they know are not long-term. We also have 2-1 buy downs now, which Candace knows because we've been talking about it a little in our office. But a 2-1 buy down really quickly, just to like lay it out, and then you guys can ask me questions or whatever. But it basically means if I lock you at 6.5, the first year you're going to pay 4.5. The second year, you're going to pay 5.5, and then back again. The third year, you're back to 6.5. The problem is that nothing is free. The payment discrepancy has to be brought in at closing. So it really makes sense to do something like this when you're getting a seller credit, because the seller can pay that payment discrepancy. So if from 6.5 to 4.5 is $1,000, I need 12,000 upfront to cover the first year. And if 5.5 to 6.5 is $500 for the second year, difference per month, I need 6,000 for that year, right? 500 times 12, 6,000. I need 6,000 to cover that year. So in total, I need 18,000 to do this 2-1 buy down. Now, let me tell you, 4.5 and 5.5 for 18,000 instead of 6.25, which might buy you down 1 point, right? 6.25 for $7,000 or whatever. Bringing in the 18 saves you much, much more money. So you ask for more from the seller to do the 2-1 buy down if the borrower is very conscious of the payment. And then you do the 2-1 buy down instead. And you can even build the 2-1 buy down into the price of the home.
Will the lender allow for that much of a credit from the seller?
Oh, yeah.
Oh, yeah. Okay. All right.
Oh, yeah, absolutely. Mhm. Yeah, the seller can cover non-recurring closing costs, and that's one of them.
But if your non-recurring closing costs are, teetering right around there, I mean, you're.
Yeah, no, you're good. You're good. You can go to 6% on most investors. So it's plenty. If you were at $200,000 purchase, you might get tricky, but most of the purchases here, there's room in that. Yeah. So that's a way. And like I said, you can even build it into the purchase price. So if your borrower is offering $750, offer $760 and ask for 10,000 back, or offer $760 and ask for 20 back. So it's kind of like a 10 credit and then a 10 build over to give them the 20. So they would do the buy down and then it would cover a couple thousand in closing costs or whatever. But so different options like that, just so borrowers feel better about the payment per month we're offering. You can do it on FHA and conventional. Jumbo loans don't do 2-1 buy downs. They're like, if the borrower doesn't feel comfortable paying this payment, we don't want to give this loan. But Fannie and Freddie are trying to alleviate the pressure of the rate.
And so overall, what would you say as a loan product would you be pushing right now? Are you a month ago, ARMs were kind of the hot thing, where are we now?
I'm still pushing that because those are our best rates. We're like low 6s. Okay. Still pushing it. It is our best option for the borrower right now. And for the first time, most borrowers are totally fine with it.
Yeah, because I mean, ultimately we are, whoever it is going to refinance in, like you said, a year, 2 years, whenever it is. But yeah.
Exactly. And the numbers are like daunting. 92% of first-time home buyers don't stay in their first house more than 5 to 7 years. So it's a large number. So the 7 years is fairly, conservative. Not too risky. Yeah. I know.
Questions, comments, thoughts, anybody?
Hi.
Oh, yes. Well, Natalie, thank you so much for shedding light on the current markets.
Yeah. We're still doing it. We're still figuring it out.
Yeah, exactly. And there are ways to, there are workarounds.
There are. And we're trying to keep our buyers positive, and I think there's lots of ways to do that. I'm having discussions with most clients that, you can actually get the home that you love. The competition is way, way less.
So,
you're not paying $100,000 more than you would have. You can never buy again for $100,000 less, but you can always refinance for a less rate.
Yes, exactly.
So,
Point.
you might be paying a little bit more, paying more in monthly payment, but not in the home. And that's a one-time thing. The payment can always come down. and it's still a tax write-off. And the part that's tax deductible is the part that you're spending more, so it's more of a tax write-off.
There you go.
If the government lets us keep it, we'll know in like 3 weeks. I voted today.
Yay. How many people voted early? Can we have a show of hands? I'm just curious to know who votes early. Oh, that's awesome. I think it's a smart thing to do. I just go to the polls on the 8th. I like to be around the people and the energy, and it's that last minute thing that I do, you know?
Yeah. I think it's great to vote in person. I'm going to be in Nashville on a work trip.
Nice.
I normally vote in person because it normally takes me that long to figure out what I want to do.
Exactly.
But I had to do it early this time. And I got to tell you, I went back and forth on so many things.
Yeah.
It's a tough one.
Fingers crossed for LA. LA needs help.
Yes, very much so.
Yeah.
On that note, I think, yeah, 6:25. So we've gone well beyond our usual hour, but thank you all for joining us as always.
Oh, can I mention December 8th? Or do you want to mention December 8th to our guest speakers? It's not the first Thursday of the month. It'll be the second Thursday of the month.
Yes, that's right. Yeah, we're shifting it this time around. That's right.
Yes. Our dear friend Tony Watson from Robert Holland Associates, tax advisor. He always comes at us with like great advice and information on like investments in real estate and how to save money. And he's our last caller, our last guest speaker for the year.
And every time he comes on, I always think I have to send in my tax return, and I have yet to do it. I am going to do it this year. I am pledging to do that because I feel like there might be some money hidden there.
Well,
So-
you've got Tomahawk now, so it's a great idea. Absolutely.
Well, guys, it was great seeing you all. Thank you
Always.
for joining us. We really appreciate all your support. And we'll see-
Ciao.
Thank you, everybody.
Very
Bye.
good.
Thank you.
Bye. Bye.